Let's go to our first question from the floor and see this as an exercise, an example, because plenty of you can do this.
Hi, I'm Linda McCaffrey and I work for the Australian Centre for Indigenous Knowledges and Education. But personally, and not on their behalf, I think it's a no-brainer that the Constitution should recognise Australia's First People. It's just sort of obvious. But I wonder if there's a risk with removing 116A that you can no longer positively discriminate as a government and parliament in favour of or to benefit Indigenous Australians. It may be not necessary, it may be time for it to go, but is that not a possibility that you're going to lose an opportunity to continue to do good things on their behalf?
Let's put that to Nova.
Shayne's
okay, Shayne's jumping up for that one. Go ahead.
Yeah, there is a risk. There is a risk because Section 5126 of the Constitution was the provision which was changed in the referendum in '67, and the proposal of the expert panel and the proposal put by the Joint Select Committee was for a new Section 51A, a people's power. If you enumerated the issues like education, land rights, etc., there is a risk that we could go back to the pre-67 days because something could fall through the cracks and the Commonwealth may not have the power and it may not sustain or survive a High Court challenge. So what you've got to have there is a provision somewhere about Aboriginal and Torres Strait Islander people not being adversely discriminated against them by way of legislative power, but there's got to be a provision in there, and this is what Section 116A subsection 2 refers to, is the capacity to pass laws to overcome past injustice. And so that provision needs to be very carefully drafted. I agree with Ken, we need to be very careful because there will be High Court challenges in this area, and we've seen High Court challenges to Commonwealth power, for example, in the Williams case, twice in relation to school chaplaincy. So you will see constitutional challenges. That's the history of jurisprudence in this country, but we need to get it right.
Yeah, I'll just show to this side of the panel, Rachel.
Well, the point, Shayne just made the point that that's why we put some of those other provisions. I was on the expert panel, so that's why I say that's why we put them in, because I was part of that process. That's why we put those other provisions in there to deal with those issues. And the word, you also see the word in 51A, advancement, and there's a lot of people that don't like the word advancement. I myself struggle with it, but the advice that we got from the lawyers was that that's a recognised legal term when it comes to, you know, challenges and those sorts of things. One of the things that people are struggling with is what is the other word you put in there if you don't put advancement in. And I think that we can't be too timid here by worrying about the High Court. Things may end up in the High Court, but it's not beyond our wit to actually come up with the best set of words that we can, and then if it's going to be tested in the High Court, it'll be tested in the High Court. Now, the other thing we struggle with is just about every different constitutional lawyer you talk to has a different opinion. And it's you know, it could be a lawyer's gab fest, quite frankly, and that's not being, you know, some of my best friends are lawyers, so that's not being rude to lawyers, but...
How much they charge per hour to go before the High Court, for example.
Exactly, yes. But what we've got to make sure is that we actually take on board what the community want in the Constitution, and particularly the Aboriginal and Torres Strait Islander community. And one of the key things that, coming from the Grain's perspective, and the panel actually said the same thing, is that we wouldn't put anything up and we won't support anything that the Aboriginal and Torres Strait Islander community don't support, which means that message we've had is it has to be substantive.
Alan, do you want to get on that one?
I agree with many things that Rachel has said, and particularly that last one. That
Can someone write that down, please?
That it's maybe the last time I say that, Rachel. Particularly that last point, that it has to have the support from the broader Aboriginal community. But again, I stress that we have to bring all of Australia on board in this journey, because I started by reflecting purely on the numbers. We've had 44 referenda in this country, and only 8 have succeeded. And those 8 have been relatively straightforward questions, and the more complex questions have failed.
But so the key there is that's been owned across the political spectrum.
It must be owned across the political spectrum for it to succeed, even when it has bipartisan support, or even, you know, tripartisan support, if that's a word.
It is now.
Then it sometimes still can fail. Now, on the question of the expert panels and the word for the advancement of Aboriginal people, I don't think that would succeed in a referendum, frankly. because there's too many people will dispute what the word advancement means, and people would argue, and I would support this proposition, that the decisions and the key values should be decided by a parliament rather than a court, and that is the body to determine what is for the advancement rather than it going necessarily to a court to determine that. So
Ken, your committee's got a pretty daunting task, it seems to me, to sort of sort the way through some of these issues.
It has, but let me say that it's been a great committee of people to work with, because we've had very frank and fearless discussions, both on our personal thinking in respect to each of those recommendations of the expert panel, but also in terms of some of the legal propositions that have been put to us in our consultation with constitutional lawyers. And the committee is very cognizant of the fact that we've got to talk with Aboriginal communities, but bring with us the rest of Australian society, and that's why we've started the process of consultation. Recognise will continue the awareness of recognition within the Constitution, and the committee of John Anderson's will also sound out where Australia is broadly in terms of preparedness to go to a constitution. Our work is daunting, but all of us have accepted that challenge, and we will come back with 2 reports, a progressive report in December on what comes out of our consultations, and then we'll table our final report in June of next year.
Okay, we've got another question down on the floor. I think there's a young woman down there with a microphone. Please stand up. Thank you very much.
Hi, Brittany Cooper, one of 35 Year 11 students from St Columba's College, Caboolture. Just in regards to the anti-discrimination clause that is being considered to be put into Constitution, wouldn't it be easier to modify and adapt the current Anti-Discrimination Act to current times rather than putting it into the Constitution?
Your teacher will be so proud of you. Nova.
That's a really good question, and what I actually am finding, which I've been quite vocal about with also the government of the day wanting to repeal the Anti-Discrimination Act, Section 18C. And when we actually presented the interim report into Parliament, I had a number of interviews, and some of the radio interviewers were like, hang on a second, we're trying to put something into the Constitution that says you can't discriminate, yet outside of it we're trying to repeal something. So that's an argument I've been trying to put out there publicly. You can't have that discussion because it's confusing people. And what Shayne was saying about that subsection 2, that answers your question. But we've got Alan saying that won't get up, and I'm listening to a lot of this stuff, and my opinion is on a lot of this is, yes, we've got a handful of, very conservative people at the political level, but that shouldn't get in the way of what, 20 million people already know. And I sort of find that Section 116 is very, very important, because it actually just doesn't mention Aboriginal and Torres Strait Islander people. It says it makes it unlawful to discriminate on your race, colour and ethnicity, which, 1 in 4 Australians are born overseas. We all know someone of a different ethnic, race or different background, and I think that's a movement that can bring Australians together.
Tony, can I respond to my fellow Queenslander on this? Can I just say this? The Racial Discrimination Act can be bypassed, and for example, the Howard government, the Northern Territory intervention, bypassed the Racial Discrimination Act. It can be overcome. If it's in the Constitution, it acts both for information and education, but it means that the laws have to be subject to that constitutional amendment. So it's a very important prohibition and halt on government action. When we came in, we made sure that the Stronger Future stuff was, of course, subject, to racial discrimination legislation. So it's a very important point. The Racial Discrimination Act itself doesn't stop this, and government can bypass it. So constitutional prohibition is important for that reason.
Okay, Rachel, I'll come to you in a minute.
That was the point.
Okay, good. Then I'll go to Alan, because just when you need Senator George Brandis, he's not here. So can I ask you, is the government going to go ahead with these changes to the Racial Discrimination Act?
To Section 18C of the Racial Discrimination Act. There was a draft proposal put out, it must be 2 months ago now, and it was deliberately put out as a draft to elicit the response from the public, and to be honest, we've had thousands of submissions in relation to it. I haven't gone through all the submissions, but I know of many of them. And I would envisage that it will be a very different proposition which is put forward as a result of that consultation phase.
We hope so. Any idea how different? Because the crucial thing will be in the wording, as we know.
It will. There was a rationale for putting the proposals forward, and it wasn't. Our position is that we don't accept, tolerate bigotry, racism. It has no place at all in Australia. But there were some people who were concerned that it prohibited some freedom of speech. Now, that was the rationale. Let's take a look at all of the submissions which have come through, and then we'll see a different response put up.
Rachel?
Can I quick point on that is that while people are trying to keep the two debates separate, 18C and constitutional recognition, when you go out and talk in community, people are saying, how can you be talking about constitutional recognition on one hand and 18C on the other? So try as people might to keep them separate, unfortunately, one impinges on the other, and people are saying, well, there's two different messages being sent. And so it is a very important issue. People are trying not to conflate them, but the community's not silly. They can see the two different approaches that are being put.
Okay, and Ken, lastly, you actually threatened to cross the floor over this issue. I mean, you think there'll be no need to now?
Look, I don't know until we see what the changes are, but my position hasn't changed on the principle of racial vilification. I made a comment in the party room, which was streamed out of the party room and leaked, where I said that in the party room, very few people would ever feel the effects of racial vilification. There would only be a handful of us that would ever experience that and feel the pain, the hurt and the grief that goes with racial taunts. And I indicated then that I would cross the floor if it took away the rights of an individual to take an action in terms of racial vilification or being discriminated against on race, and said that I would do it on the principle that all people who would be subjected to racial taunts or racial vilification will need that protection. In an interview I did with the ABC, I said to the journalist, one day Caucasian Australians may need that act because they are in the minority and so therefore they require the same protection. So my position hasn't changed. I will wait to see what the legislation is, but it goes to a principle, not a political cause.
Okay, I think are there any questions out there? Yes, we've got a question down on the floor here, and we'll get a microphone to you. Thank you.
My name's Hugh Taylor, and Alan Tudge mentioned the right of free speech. And a week ago I was listening to Gillian Trigg, the Human Rights Commissioner, who talked at some length about the freedoms and rights that we think we have that we don't actually have. That the Australian Constitution does not have any rights inscribed in it. Our common law is based on Magna Carta, but it actually doesn't carry any weight in the Australian Constitution. So there is no right of freedom of speech in Australia. There is no right to be charged before one's detained. There is no right to not to have executive privilege in restraining people. She was talking particularly in terms of the refugees who are coming to our island, to our country, who are misnamed. But the lack of a Bill of Rights of some sort sets us apart from every other democracy. In addition, that there's no regional court to test us. So should we be looking at a Bill of Rights?
Yep, I'll just throw that to Alan, and I think one of your fears, isn't it, that the Bill of Rights question gets somehow tied up in the referendum issue and it gets confused one between the other?
Yeah, I think that's right. A Bill of Rights, of course, would have to go to a referendum to get up. I wouldn't support, and I don't support, a Bill of Rights because I think it transfers the decisions and the power and the questions which are ultimately about values from the parliaments across to the courts. That's what we've seen in the United States. It's what we see in other jurisdictions which have a Bill of Rights. I think that the key questions which concern a clash of values are quite rightly decided amongst elected representatives rather than amongst appointed High Court judges.
Okay, I think I might change topic now, because I did forecast a few things we'd talk about, and I'll switch to the Twiggy Forest Plan, which I didn't hear any direct references to this in Bill Shorten's speech. So, Shayne, maybe you could tell us whether you're considering the plan, whether there are elements of it you're in favour of. There are a couple of oblique references in Bill Shorten's speech, but nothing definite. Can you tell us anything definite?
Well, we've only had the plan a few days. The government, presumably, because the plan was supposed to be delivered to them by April, would have had it for a lot longer than us. And it's a plan to government. It's a comprehensive plan. I've spoken to Andrew Forrest a number of times about it. I intend to meet with him, and I know other shadow ministers do. We want to be as constructive and bipartisan as possible in relation to it. We want to see and have a chat with him about the proposals. There are some things, his emphasis on a website. We have seen the My School website being successful. We've seen in the other aspect of my shadow portfolio in the area of ageing, my aged care being a successful website for transparency, accountability and measurability. So I think there's some merit in that. I think the emphasis on early childhood education and wraparound services, certainly when Labor was in government, we brought in the children and family centres to keep kids prepared for school. The current government seems to put a big emphasis on truancy, but we think getting kids prepared for school and getting mums and dads prepared for their children to actually make that transition is really helpful. So he's put some good things there. What Bill talked about today is we do not believe that that putting 2.5 million Australians on a sort of income management proposal is really what the Australian public has to say. Bill talked about dignity. There is dignity in a free society, in a free enterprise economy, with people having the capacity to make decisions in relation to their own family situations. And we do believe in income management in the Labor opposition as a last resort in family dysfunction at its height and individual incapacity, but only as a last resort. And only about 24,000 Australians are currently income managed, and many voluntarily. So we're happy to talk with Mr Forrest about that. We believe in good evidence-based policy, but at this stage we're considering the report in detail. There are some things which seem to have some merit, but we'll talk to him further and make our own decisions.
No, can I bring you in on this? And it seems to be Twiggy Forrest's idea that you need to have this healthy welfare card in order to break the kind of perception that income management is discriminatory and targeted particularly at Aboriginal people. What do you think?
Well, it certainly is, and I know recipients, and I saw firsthand when, you know, I've been at Woolies in Alice Springs, where you've got a line that's for basic card holders only, and then the rest of the aisles for people who has their normal savings account. So you walk in and you look and you see black people lining up with, you know, and it attacks their, and that's what Shayne was saying, it's all about the dignity and their self-worth. And, you know, the Northern Territory has just, they've been recipients of horrible, I guess, systems and policies of government, and it's just been thrown upon us. And
you regard it as some sort of paternalism?
Yeah, very much so. And, you know, like, I haven't read Twiggy's report. I've been out bush. I only received a copy yesterday, but I did hear him speak yesterday, and he made mention about how important early childhood education is, and for 0 to 4-year-olds, and, you know, getting them school ready. And what Shayne was saying, and I travelled with Warren extensively last year and saw the significant amount of investment that was made into these respective communities. And the thing that's so frustrating amongst Aboriginal people is when things are a good thing, then a change of government comes along and rips the crap out of communities.
They cut the funding.
They cut the funding.
They cut the funding.
And, you know, and all these early childhood education programs have been cut. And you talk about the justice, you know, investment. We've heard from people talking about what air, when you've got the largest Aboriginal community in the whole of Australia, just under 5,000 people, 50% of them are under 18. There's probably no more than 50 jobs But, you know, you can't create economic development when, you know, for decades upon decades we've been promising a road. You can't get anything into these communities without proper infrastructure. And it's just keeping, you know, Aboriginal people on an all-time low. So if you really are truly in fair income, and, you know, what Rachel was saying about all this policy, everyone comes to places like Garma, they walk away, it's like a real feel-good, warm and fuzzy feeling. Oh, how do we fix Aboriginal affairs? Listen to the people. You've got so many amazing people that have come up with innovative programs. Just take their documents and say, shut up, listen, do it. And you'll find people empowered and people being able to live equally within this country.
Okay, I'll throw you... no.